Start. The appellant herein, who is a practicing advocate, had suffered in a nasty accident at the young age of 18 years. Stop. He was a student at that time studying in Modern School, Delhi. Stop. It was 26th May 1988. Stop. He was traveling along with his mother from Delhi to Mussoorie to celebrate his 18th birthday falling on 27th May 1988. Stop. On Delhi Dehradun highway, the accident took place in which his entire left leg was crushed. Stop. He was rushed to the hospital and his hospitalization continued for over 2 months. Stop. He had to undergo surgery for which he was operated on 31st May 1988. Stop. Though the appellant was discharged from the hospital after 2 months, his treatment continued for over 6 years, during which period he had to undergo further operations. Stop. In all, 3 surgeries were performed. Stop. First, for putting plates and screws, another for removal of plates and screws, wherein doctor discovered that he could not remove the plates and screws of femur bone. Stop. The result is that even today the said screws and plates in the femur bone remain planted. Stop. This exposes him to the risk of another fracture anytime. Stop. The third operation was for removal of a lump in the right leg which had developed after the accident and had grown over the years. Para. The appellant filed the appeal there against before the High Court. Stop. However, when it was taken up for hearing, nobody appeared on behalf of the appellant. Stop. Going by the fact that on several consecutive dates the appellant was not represented and remained absent, instead of dismissing the appeal in default, the High Court decided the matter on merits after hearing the counsel for the insurance company and on perusing the record. Para. Main contention of the appellant in appeal was that MACT had failed to take into account the disability certificate which showed that the appellant had suffered permanent disability to the extent of 40%. Stop. This submission is rejected by the High Court with the observations that the MACT had in fact calculated the loss of future income on the basis of inference that the claimant has suffered functional disability to the extent of 40% corresponding to affecting his earning capacity. Stop. However, as for the High Court, these income tax returns were irrelevant and could not be taken into consideration as accident occurred way back in the year 1988 and therefore compensation had to be fixed with. Stop.